Surprise. Turn over to John for whatever we have now. Thank you. Open mic again?
Yes, we're getting towards the end of the day. We have 30 minutes for open mic and closing announcements, and we adjourn. Open mic session is where we open the microphones for any topics that haven't been discussed, any additional questions. Sometimes this can be 5 minutes long, and sometimes it can be the main event. So I'm now going to open it up to open mic. This is people in here and remote, participants who have a question that they might want to ask, or discussion, or raise a topic that hasn't come up. Okay, this microphone on the side first.
Peter Timish, Adrex once again. One of the things that we wanted to find out and wanted to know how the community felt about this is, unfortunately, we are now getting a wind of a lot of the AC members are also working as, the better word, consultants, paid whatever for certain brokers and attorneys. We kind of want to make sure that's something which either is vastly discouraged or it's required if you're an AC member that you have to disclose that you are also being paid by a broker or by a lawyer. We as a process, Adrex does not pay any outside consultants. We have our own attorneys, but we are hearing this quite a bit, and we are deeply disturbed that there is several members of the AC who are being paid to be consultants outside their normal job.
Can I ask a question just for clarity? Your concern is that AC members are busy working on policy, and the bio that they publicly have on the website may not be complete with respect to these consulting?
Correct.
Okay. People want to speak on that topic? If you want to speak on that topic, be at the mic, otherwise take 2 steps back. I have, who do I have who wants to speak? I see Owen and RS. Owen?
Owen DeLong, Akamai, ARIN AC, and somebody who occasionally does consulting gigs for people looking to acquire addresses. I have not done any consulting gigs where I've been paid by a broker, except for one where the end customer of the broker, for contractual and legal reasons of their own, chose to pay me through the broker, and so the broker passed my fee billing through to the client directly without markup, but I was still effectively paid by the end client. I have always been paid by the end client and not by the broker or attorney. And I don't believe that working for organizations that request address space on a consulting basis represents any sort of conflict of interest. I have readily disclosed that whenever it's been asked of me, and I do not understand the concern.
Okay, RS in the back.
So I have provided pro bono advice to organizations that are trying to get their request for address space approved by ARIN. I have not accepted money for that except in the ordinary course of my employment. I have personally held V4 and ASN number resources, which are part of my disclosure as potential conflicts of interest, and we have all made disclosures of potential conflicts of interest, which I believe are minuted in our annual meeting, and you're welcome to avail yourself to those minutes if you like.
All right, just for clarity, so all the AC members have a bio on the website, but also at the beginning of the year, they look to each other and detail their activities. And that's something that they do so that AC members know when they're in the room and they're discussing policy, whether there might be a potential for conflict of interest. Now, some of that is confidential because some people sometimes have business dealings you can't publicly post. You're prohibited from doing so, but the AC members know they have to do a disclosure to each other at the beginning of each year in addition to their bio. But if that's insufficient, that's something certainly worth talking about. And microphones remain open on this topic. Anyone wants to talk about AC? Yes, go ahead. AC disclosure.
Hi, Amy Potter. I'm on the AC and a broker, and that is something I disclosed when I ran, and I think that's actually a big part of why plenty of members of this community voted for me to be on the AC, but in case anyone wasn't aware, I am a broker and I do get paid for selling IP addresses.
Okay. Anyone else want to comment on this?
I'm here for a different reason, but I might as well because the lawyer in me can't resist on this. So I guess I don't see it that much differently than any other interest that an AC member might have with regards to their employment or contracting generally. And the one thing I'd like to remind everybody is that when you're facilitating a transaction, it's about interpreting existing policy, not making new policy. And the time frame is usually very short. You're not going to be able, typically, even if you wanted to, affect policy to try and facilitate a particular transaction within any reasonable time frame. It's just, to me, it makes less sense to worry about that than other possible situations. And as I said yesterday in the newcomer session when we were talking about, why the whole process works so well, at the end of the day, it's the Board of Trustees that have to be concerned about the real conflict of interest as part of their fiduciary duty. That's where the buck really stops on that issue. Okay. So those are just some remarks. I don't have an axe to grind one way or the other on this. I just wanted to make those remarks.
Okay.
Yep. I wonder if I could get in the queue.
Sure. And I also, Steve, you wanted to comment?
So,
Steve?
I think I'm Steve Ryan. I'm the general counsel of the company since, I think, 2004. From a standpoint, I want to close the issue on the board. The board does written disclosures. Those written disclosures exist on an annual basis and are changed every year, and they update them if their situation changes during the year. And it is correct what Mr. Tassett said, that the board has a financial and fiduciary obligation to the company that is different than AC members. So from the board's perspective, there is, I think, more than full disclosure of any employment or compensation issues. With regard to the AC, the situation is different. The AC is not in a fiduciary obligation standpoint. However, I wanted to just emphasize that in January of each year, each member does disclose their unique relationship to the community so that their fellow AC members will understand that relationship. So for example, if you have a single employer, you explain your job at the single employer. I think actually Peter's point, though, is an important one, and I think it's worth thinking about whether spot assignments during the year are adequately addressed by that, and I think we can evaluate that. I think it was helpful to bring it forward. And if anybody is ever concerned about the confidentiality of information in the AC, generally the AC is not exposed generally to confidential information. There are times when they'll be briefed on an existing legal matter, although that hasn't happened for several years. There is also a non-disclosure agreement that each that each AC member signs if they receive confidential information, and it's emphasized as confidential information. They cannot share that without violating their non-disclosure agreement. So we do have some, I wanted to just share the panoply of how we've addressed this, because I think we have good systems for this, but this is a new issue, and I'd like to think about it with the AC and with the board, and I appreciate Peter bringing it forward.
Okay.
If I may, real quickly, we have absolutely no issues with the way the board disclosure is. We've looked at it, and we're actually very proud of how you've done that job. So a kudos to how that's worked out. You're right, this is a new issue and something we're now getting. It's a feedback loop that we talk to people, and we wanted to bring that forward for everyone to discuss instead of just at the AC meetings. It should be brought forth here for people to discuss whether they would like to know more about how that is being built. So that's our point.
You're in queue, Vin?
I just wanted to get some clarification. Is the issue simply a matter of transparency? Is that why this was brought up? Or is there, in fact, a specific concern about conflict of interest? I hadn't been able to figure out the nature of the conflict, and
It's
I
a
wondered
combination of both, Dr. Scherf. We look at it first as a transparency issue because people should know. Amy Potter is very clear. She works for a broker. She is on the advisory council. People know how she works. It's not a question of transparency for her. But we are getting, unfortunately, because we are very active and there's probably 50 people in this room we work with, they will come to us and say, hey, I was at a party, I heard this, and it's kind of stunning to us that it's not something that was added to the list. But that's right. Steve Ryan's correct. This is new. And so there is the potential, though, for a conflict because they are now shepherding or stewarding certain things that may actually either help or further their own just area. And so we do kind of, policies make big differences in how well a transaction goes through, or in a weird way, it can actually make it so it makes the bar much higher and keeps them so they are still a cottage industry. So we are concerned about the conflict of interest as much as transparency.
So, John, may I continue? So let me try to summarize. You're saying essentially that a party who is providing advice, paid or not, might use the policy development process in order to influence the course of a transaction or future transaction. And that's specifically that is the nature of the conflict that you're trying to expose. Is that correct?
That is correct.
Okay, thank you.
Okay. Well, we'll definitely take that with council on the board as well. Milton's been waiting.
I'm sorry, Kathy Aronson. The reason I was originally on the AC a really long time ago was because I needed policy for my company. I mean, everybody knew where I worked, but the whole industry that I worked for needed policy, and I worked on that, and we got consensus, and we made it policy. So I didn't think that was against the rules. Is it just that maybe nobody knows that they're doing whatever they're doing and then they're getting policy for that? Because I was clearly on the AC for a long time to help the cable industry have a decent policy where they could get address space and succeed in business.
Right.
So
The question would be, if you're on the AC and helping get policy that allows satellite companies to get address space, and you didn't tell anyone you were consulting for a satellite company. I don't think it's a question when we all know everyone's relationships. It's some people may have dynamic relationships that have started up where they're consulting for an entity, and if they're also working on a policy, that's germane for everyone to know. Their advocacy may not be entirely based on what they hear in the community. Milton.
Yeah, I think one of the things I've heard about is not so much that, oh, you're working for a cable company or this company and you're shaping the policy in a way that favors them. What I have heard, and this is not something coming from me, it's coming from third parties who have asked me about this, is like, why do certain people seem to continue to support certain intricate needs-based policies when the rationale for them has gone away? And the speculation, and I'll call it that fills the gap is, well, maybe they're like these complicated, arcane policies because they're helping people get through it and they're consulting. I have no direct evidence that that's true. It could be, it may not be, but I have heard people speculate about that, and it's directed at AC members, not at board members.
Okay. Okay, and so to the extent that someone has a business in advising people on policy process, then that's probably something that's important for people to know, because the nature of the policy process itself is germane to their business.
It's not really the policy process. It's the fact that they're not simplifying the policies. The assertion is they're not simplifying and streamlining the policies because they benefit from it being complicated.
Right. I was not thinking about whether it was complicated or simple, but just the idea that they're in the business of facilitating it. If people know that, then they understand indirectly complexity improves the volume of business. Okay, so obviously someone who's advising people on how to go through and make requests under policy, that's a business segment that is important to know someone's employed in, one way or the other. Okay, center front?
Yeah, so I'll just add a comment on that and then see if that's it for that topic. But it seems to me that if the NDA requirements are observed by AC members and there's sufficient disclosure, we can't really do much more than that. Otherwise, there wouldn't be an AC because everybody has a master of some sort, whether it's a consulting company, or whether it's an employer. And at the end of the day, everybody on the AC has some interest in helping to advance those interests in terms of policy development. But the group as a whole is still trying to work for the benefit of the community, and there's balance because of we do take into account the community's interests, and because there are 15 of us who come and go at different times during the 3-year cycle. So
It's entirely a question of completeness of disclosure.
because otherwise there would be no AC. Everybody would be conflicted.
We'd all be conflicted out. It'd be an empty room.
Yeah.
But very quick meetings. Yes. On this topic.
Yes.
Yes, go ahead. Rear mic.
Kevin Bloomberg. So 2 things. I look forward to whatever the review shows, but I think, quite frankly, you're doing a great job, and the AC is doing a great job. What I would say is this: if you look through the history of the meeting minutes, the number of people on the AC that have abstained for conflict, or even for the perception of conflict. I'm in tangentially this industry. I don't feel comfortable voting. I have an absolute respect for the colleagues I was with on the AC for those years, and any disclosure is good disclosure, but I have a lot of respect for all of those people.
Yes. Chair?
Yeah, I just thought it's important to say, the board, on behalf of the board, the board takes conflict of interest very seriously. We've kind of noted our procedures in that. John has instilled, I know, in the staff the importance of that, and the AC has been doing their process for some time. My experience is they do take it quite seriously and all that. Having said that, council has noted that there's an issue here that might be worth noodling on, because if there's improvements to be made, there is. So I really think the issue, and we will, once council reports back, the board will advise. So I just wanted to thank that for bringing attention.
Okay, ready for the next topic? Center front.
Thank you. So I wanted to pick up on a comment I made during the discussion of one of the policies earlier, because I don't know about other AC members, but I need this help and guidance from the community to help me sort out the policies we discussed today that were overlapping. And the questions I'd like to ask are this: when it comes to the tests for transfer, does it matter what the size of the block is in terms of how stringent the test should be? And 2, when it comes to the evidentiary requirements required to support whatever the test is, does it matter what size the block is? And the reason I ask this is because I've noticed the tendency, which I mentioned earlier, for us to look at these things in a rather black and white. Some people completely opposed or completely support. But I don't know if people have thought about nuancing this and saying, well, if you're getting a /24, maybe the test should be lighter, maybe the evidence should be less than if you're getting a /16 or whatever. I don't know what the answer to that question is, and I don't know whether the community wants to go down that path at all, but I'd certainly like to hear what people have to say about it, because if it's more of a continuum than an either or, then the AC has some work to do in finding the sweet spots for that.
Okay. People want to respond to that topic, whether or not the criteria or evidentiary requirements should vary based on the side of the block. Center front.
Owen DeLong, ARIN AC, Akamai. I do think that it should vary somewhat with the size of the block. I think that we can be a lot less cautious about /24s and maybe even up to /16s than we want to be with, say, /12s and /10s and larger blocks, if there are such things. So that's one of the reasons that I supported the policies that I supported, which had a more nuanced view, and opposed the policies that were more absolute.
Got it. On this topic, Senator Mike?
So I really don't want to talk about existing policy because I think we had time to talk about existing policy. I do want to confirm that when it comes to the needs test as a whole, that is not in policy. That is ARIN staff deciding and making sure that they follow an initial set of guidelines, but if they feel they want more information because there's something wiggy going on, they will ask for it, and that is for staff to deal with. We say need, you do the rest.
There's a criteria that's specified in policy. We ask for evidence of that, of meeting that criteria. There are some times that we will put a credence level on the evidence you give us, and we will ask for more evidence, and that can go on repeatedly. It is not common, and a lot of people, particularly new organizations that have no record, that have interesting documentation that seems to have fallen out of a Perl script, may disappear the third or fourth time we ask for more detailed information. It's very hard to, it's easy to fabricate, it's hard to answer the follow-up questions from fabrication.
Right. I don't know how to say, please make a lighter touch, because at the end of the day, it's the staff's judgment.
Okay.
Thank you.
On this topic, any other responses? Yes, Senator.
Yeah, just one on this topic. I actually had a question for everybody about actually how much scrutiny there is in the smaller blocks, like the /24s, 22s. After being managing a number of those blocks in various organizations, I see that as kind of some of the worst stewardship. And I say that after working through cleaning up and trying to become a better steward of these things in those organizations. But it's an overwhelming problem for ARIN just because of the sheer number of blocks, right?
Sure.
So how much attention does everybody actually want to pay to this particular problem as opposed to moving forward with V6?
There's two questions there. The question is, what's present policy and what does people want? Present policy doesn't distinguish between that /24 and that /20 and that /18 when we're busy doing our validation. We're still looking to make sure the source is valid, and we're still making sure that the recipient has documented need, and we're not applying a different level of evidence unless what we were given is somehow questionable. We can do that, but that would need to come from this community about at least what thresholds, give us some ranges in which we should relax evidentiary criteria.
Well, with I guess the expense of diving deeper into this problem, is there actually a desire from ARIN to do so as a group?
I want to be very clear. You need to distinguish very carefully, if you're going to have us relax the approach, whether you're referring to needs assessment or whether you're referring to source validation. Because in the case of source validation, we're trying to confirm whether that's the actual party that was assigned the resources, and if we get it wrong, there's a harmed party out there, okay?
Understood.
So just let's be really clear. Okay. Yep.
It feels to me like this is largely a risk mitigation issue. And what John just said about potential hazard of a person showing up and who's faking source information, that's a pretty serious problem. On the other hand, let's suppose for the sake of argument that small allocations didn't get as much scrutiny as larger ones. This is similar to what happens in some credit card transactions where anything below a certain amount doesn't require a signature or other thing. I'm not advocating one way or the other, but I would like to suggest if you reduce the level of scrutiny with regard, let's say, to meeting criteria for receiving a transfer, would you end up with a run of large numbers of small things because they didn't get looked at as carefully? And what would that do to the staff? So this is a non-trivial question. It's not a simple one.
Thank you.
Remote participant, Milton?
Yes, it's a different topic.
Oh, let's hold on it. Just keep it. On this topic, center front.
Patrick Gilmore, Markley Group, board candidate, but speaking for myself. As a member, just to answer Christian's question, I actually would support the idea of doing something different for small blocks and big blocks. And I totally recognize everything that's gone before about, Dr. Surf mentioning a run on small blocks and other reasons why this may or may not be a good idea, but he asked if the community would support it, and I'm a member of the community, so I'm saying that if the AC came up with a plan like that, I would probably support it. I'd obviously have to see the actual policy before I can say for sure, but I have no problem with small blocks, for instance, 24s having essentially no validation or something like that, other than you can't have two in the same org or something. So hope that answers your question.
Okay. On this topic?
So, David
Senator
Newman, Oracle, how handy of a conversation? Because tomorrow we have a fourth policy in this vein to discuss. We only got through 3 of them today. And that fourth one tomorrow is exactly this. It's a very simple policy that says if you are requesting less than a /16, you can, if you are requesting to transfer into your account a /16 or less, you can get up to double the amount of space you have with no needs tests. And we'll show statistics tomorrow on how much the utility of that and how relevant that is. So stick around for tomorrow because that policy is on the docket.
2016-3. Yeah. Okay. Rear microphone, same topic? New topic. Okay, I'm going to go to the remote then. New topic.
This is from Kevin Ott, OTTE. At NANOG, I noted there were 2 presentations on IPv4 transfer markets. At this meeting, we've had 4 policy proposals surrounding that market. We know that IPv6 is the way forward, and yet there has been little talk this week about actually making that happen. ARIN has a great campaign in the form of Get 6, but there seems to be a disconnect between that and the policy discussions here. Is there something we can do to make IPv6 a more attractive option to those who might feel they need to approach the market?
I'll take people who want to respond to that. I'm going to take the opportunity myself first and say, note that policy discussions in ARIN are not an indication of level of interest. They're an indication of fixing something that may not be working well. The absence of IPv6 policy discussions may indicate really good policy. Okay, anyone else want to respond? Go ahead. On IPv6? Yes, go ahead.
Izumi Okutani, with the head of IPv6 coordinator within IGF for the best practices. Excellent question, and I also agree with John's observation that this is a good sign that in terms of number of resources, we're actually not facing issues. But if you want to contribute, there's a place that you can actually share your business cases. We're actually working this year in Internet Governance Forum on documenting what are the business incentives and what are the successful cases on IPv6, targeting policymakers and business decision makers, which hopefully would actually make a difference in moving things forward, not just on technical level. And we really would like to hear more cases from North American region. For example, companies such as Google, Yahoo, LinkedIn, Apple. We really haven't heard from those companies. So we really would appreciate your contribution. And we're actually planning to publish a draft document. So your input, again, would be appreciated. I'm actually handing out stickers on this forum. So if you can go to ARIN's desk, you can collect more information with the URL. So thank you so much.
Thank you. On the V6 topic, Center Front.
Owen DeLong, Akamai ARIN AC, and as some of you may have known, I was once an IPv6 evangelist for a few years. I'm still relatively active in trying to evangelize IPv6 and trying to get people onto IPv6, including parts of my own company. Having said that, I think that the lack of V6 policy discussions really is a sign that we've made the V6 policy as simple and attractive as we possibly can, and that people are generally happy with it. We had little trouble at Akamai getting our V6/24 squared away, and the existing policy was quite useful, and we were able to get what we needed, and we think that'll serve us for at least a couple of years, and we're in good shape. Okay. So I don't think that we should conflate how much V6 policy discussion there is with the level of interest in V6 or the amount of push for V6 that ARIN is engaged in. I also think we need to be careful. As much as I'm a huge fan of V6 and, die V4, die, please. I think that ARIN doesn't have a role to evangelize the death of V4. I think ARIN, as a registry, needs to remain protocol neutral in the policies and in their actions, and that while they've done a great job of pushing the industry towards V6 in the interests of the industry, that going any further than gentle encouragement departs from ARIN's mission statement in a non-trivial and harmful way.
Okay.
So I think we're in the right place.
Okay, thank you. V6?
Yes, Scott Morzo, IRS. Way back in the dark ages of V6 when we got our allocation, we actually encountered quite a few policy-based issues that we had to work through. It's my perception that at this point in time, those problems have been addressed in policy.
Excellent. Rear microphone on V6.
So 2 quick things, Kevin Bloomberg. The first is that penalizing people is a really bad idea. And I know over the years we've talked about reclaiming V4 to try to extend it along. We've talked about penalizing in V4 because V6 is the way to go. That is not good. That hurts small players and it hurts our image. Penalizing is never a way to get things adopted. You support them both. You really make it as easy as possible, which is, I think, what is going on with V6. And the only concern I have that we've seen in the last, I would say, 2 years is where people who got space originally had some sizing issues, and I believe as a community we resolved those.
Okay. On V6, any other speakers? Okay, I'm going to move to new topics. New topics, center front.
New topic, but I'll use that last question as a perfect segue. So as we know, the ARIN run out occurred a little over a year ago, and I think what we're seeing right now is people that have tried to squeeze, stretch, and economize as much as possible, and over the past year, more and more players have pretty much exhausted every last resource of V4 as they had, which is why there's so much more activity happening in the transfer market, and so many new people are talking about it that even as recently as a year ago had no interest and ever imagined they would enter the transfer market. So that being said, I mean, we can see that by the fact that we have four very similar proposals to talk about this week that all have to do with the transfer market. And thanks to Amy's wonderful handy reference guide, I did some research, and when I was trying to learn how all of these talks relate to each other, what's the nexus of talk A versus talk B, I looked at the original authors, and I found it really interesting. I don't want to necessarily name anybody, even though this is a compliment. First of all, I wanted to give appreciation for, of the 4 people that worked on these policies, 3 are active AC members. So thank you so much to the 3 that were involved for your diligence and your hard work on these. So that's just a compliment. Thank you for working on these. But I also found it a little troubling that as a community, there was 1 non-AC member who worked on one of these, and there was nothing else being proposed by the large holders, by the brokers, by the large sellers. This really is a hot topic, and I do encourage people. I myself made a proposal last year. I encourage people that actually are affected by this to speak up. I found the ARIN AC members very approachable. The Shepherds were extremely helpful. I had no idea how to write a policy, and I think if you have a proposal and it's not being met, I encourage people to not sit back and let the AC do the job of what I think the community is. I think they're filling a gap because they're very involved, they're very present, they're very knowledgeable, but anybody in this room who has a strong opinion about how things should be, how we should be charting this course should speak up. If you don't know how, find an AC member. They're wonderful people, very helpful, very approachable, and make your voices heard. I don't think it's right that the AC plus 1 very active individual are the only people that are contributing. I think we all deserve, the community deserves a lot more from us as individuals.
Okay,
Thank
excellent point. You want to respond to that?
I do.
Go ahead.
I can't speak to all of the details of these, but a lot of times the AC gets input from the community and then creates a proposal on their behalf. So some of the input to these policies that exist come from the community. So that is a thing that does happen.
Yeah.
So.
There are contributors out there who may not be the ones to take a lead on a proposal, but have been instigators or suggesters, and that is worth noting. Okay, I'm actually going to close the queue because we're running out of time. So last one is rear microphone. Go ahead.
Kevin Bloomberg, and this is not about policy. Who was? We had a great set of talks yesterday at NANOG,
right.
And what came out of it was that some of the buyers were seeing major levels of fraud. When you say 30% in a presentation, gave some really good examples of things to avoid and things to do. Use who is and look up the block. Go to RIPE and get a history of the rounding table. But nobody brought up who was during the presentation, because if you actually look at the use case for who was, you can't really use it as a buyer to start looking at potential blocks that you've been told you can bid on, as an example. It's not explicitly stated, and there's some very explicit statements in there. I checked with staff earlier today, and they said, no, you really can't. You have to follow one of the very specific things. And I would strongly suggest, especially as this market grows and the fraud incident cases increase, that giving that phenomenal tool of the entire history of a block to the buyers, allowing sellers maybe to have a cryptographically signed PDF as of this date, or whatever it may be, but expanding on the who is service to allow for the market to use it.
Excellent. So as it turns out, the who was service will provide you the history of any block. The problem are the terms of use. The terms of use don't specifically say, for purposes of determining the pedigree of a block, whether you're the buyer or the seller. And probably we need to look at that. I think everyone realizes it's in the community's interest to allow that. And if it's not specifically in the who was terms of use, we can get it there. You can, once you've been approved to the who was service, you can go back and pull the history of any block you want.
Right,
They're all
it's
available.
it's specifically the terms of use.
And we can, staff will research that and bring it to the board to discuss. I think it's fairly clear that that's a use that is in the community's interest, but if someone feels otherwise, let me know. Otherwise, we'll proceed down this path.
Thank you.
Okay, that was the final question. We will have another open mic tomorrow.